Okay, so thank you for coming, everyone. I'd like to introduce you to Zahava Schechter, who is an estate planning and administration attorney. So she will be speaking tonight about basic estate administration. So go ahead, Zahava, you can take it away.
So good evening, everyone, and thank you so much to Christy and to the Bayville Library for having me back again. I really appreciate the opportunity to present what I hope will be an informative, interesting, and entertaining program for you. I hope everyone can hear me and also see my PowerPoints, which are already up. If you have a problem seeing it, let me know. This is my contact information. I just want to say before we begin that I will not be giving legal advice out during this program. If anyone has a question, feel free to call me. I won't charge you for a question or two. So feel free to either put your question in the chat box or, as Christy said, or you can ask at the end. And that's, again, my phone number and email. So I just want to tell you a little bit about myself and why I'm presenting this evening. This is the second part of a two-part program. If you missed the first part, don't worry. Christy has it on her YouTube channel or on the library's YouTube channel about estate planning. Today, we're talking about estate administration. Here is what I do, and I am an attorney in New York State more than 30 years. I also have a podcast. In fact, I'm recording another episode tomorrow. If you like to listen to podcasts, it's available on for free on Apple, etc. And you may find it interesting. It's all about Long Island legal issues. So we're going to dive right into our program tonight, which is on elder law, estate administration, and guardianship, and all the other issues which we didn't get to in the last program. So you see here a definition from Wikipedia about what elder law is. A lot of people ask me, are you an elder law attorney? So I am, in that I do specialize, or I concentrate my practice in issues that affect the aging population. We're all living longer, and so these issues affect all of us. And of course, the time to get all of your legal affairs ready and in order are when you are well. And I'm talking about a mental wellness. That's what we're going to be talking about mostly tonight. Mental fitness, capacity, and the ability to understand, to communicate your wishes. Not so much a physical issue, but more of a mental issue. I don't know the other participants tonight, but I would say most of us want financial freedom and autonomy as we, not only whatever age we are now, but as we age through the process. And really the only way to do that, to make sure that our wishes are honored and that we remain in control of what happens to us, is through proper planning. So let's talk about the various issues that are under the umbrella of elder law, estate planning, which we talked about in the first program. If you were here a few weeks ago, that means planning, preparing for death or incapacity. And I just want to say now that when I talk about estate, you can't say the estate of Zahava Schechter because I'm still alive. The state, when you use that term, it has a definite legal particular meaning someone has passed. So planning your estate, planning ahead of time, and making sure that your wishes are honored is what we're discussing here. Administration is after someone has died, whether that person leaves a will, of which only about 40%, only about 40% of all American adults have done any kind of planning, which is a very low number. So if there's a will, then we're talking probate. That may be a term you've heard of. If there's no will, it's an administration. And tax questions. Tax consequences are very important. I actually just sent a letter out to my clients telling them that there is legislation pending in Congress about reducing the estate tax threshold, gift tax threshold. So tax consequences and liabilities are very important. Let's face it, you've worked really hard to earn your money, to save your money, to invest it. You don't want to pay more than your fair share to the government. So that's a very important thing. And I want to take this opportunity now to say that part of your team is not only the estate attorney, but also a really good certified public accountant. that person can help you not only with your tax returns, but also tax planning, tax or asset preservation. So that person is definitely an important part of your team. And also involved in elder law are Medicaid issues, disability issues, and other long-term care issues. I want to talk about this briefly right now. Medicaid is different from Medicare. Medicare is an age-based governmental benefit. If you're 65 and if you're extremely wealthy, you still qualify for Medicare, reduced or subsidized health care expenses. But Medicaid is different. Medicaid involves an asset-based test. Medicaid is for poor people, really poor people. We'll talk about that a little bit more, what that means to be poor here on Long Island or elsewhere. So a lot of people want to plan for Medicaid, but that often involves losing control of your assets. There's no panacea. There's no one way to save all of your assets for your children or your spouse or your loved ones or whatever, or whomever you choose, and also to qualify for government aid. And shouldn't it be that way? Because we as taxpayers pay into the Medicaid system. And so we want our tax money to be used fairly, but we'll talk a little bit more about that later. Disability insurance in particular, if you don't have disability insurance and then you're unable to work, that's a problem, right? Especially if people, not only for your, for taking care of yourself, for paying your own bills, but what if people rely on you, if they're dependent on you financially? So that's something that definitely we will discuss, and long-term care issues. So Medicare does not pay for long-term care issues. I'm a big believer in long-term care insurance. I don't sell it, but I first bought a policy more than 20 years ago. And even if I never use it, that's fine. If I ever have to use it, what I've paid in premiums will be a drop in the bucket, because long-term care is very expensive. And what I see from clients who have not either purchased insurance or made those plans, they have to wind down, they have to sell their assets to pay for whether it's nursing home care or home health care aides, etc. So that is definitely something to look into. Especially if you're not sick yet. Once you have a qualifying event, you're no longer going to be eligible. So it's one of these ironic facts in life. The time to get all of this protection in place is when you're well, before you need it. If you already need it, it's probably going to be too late. Okay, we will talk a little bit about guardianship. In other states like Connecticut in particular, they call it conservatorship, but guardianship is when someone, particularly an adult, that means over the age of 18 in New York State, cannot make decisions or act on his or her own behalf. Again, we're talking mental capacity, and then a guardian is named for that person. Okay, so we started talking about Medicare and Medicaid, and just be aware Medicare does not pay for long-term care. All right, so let's talk a little bit more about Medicaid now. There is a two-part, like a bifurcated system to Medicaid. One is nursing home Medicaid, and one is assisted living or community-based Medicaid. The current Medicaid look-back period, and I'll explain that in a moment, is 5 years for a nursing home and 30 months, 2.5 years for a community program. So I want to explain what look-back means. That means the period during which, from the day that you apply for Medicaid assistance, the government, which, by the way, the program is administered on a local level by the Department of Social Services here in on Long Island, whether in Nassau County or Suffolk County. In the city, in New York City, it's dealt with by ARC, but it's a New York City-based office. And they look back 5 years or 2.5 years from the day on which you apply to see, were there assets which you transferred or sold or whatever you did with them, even if you gave them as a gift to your children, which could have been used for your care, and but for your sale or transfer or gift, you would have money. You wouldn't need to apply for Medicaid. If so, Medicaid then says what that department, whether in the counties or in the city, Medicaid says, wait a minute, you purposely transferred that money, so we are going to take the amount that you would have paid for a certain period of time. It's a little more complicated, this computation. We're going to take a certain amount, and you'll have to pay that amount until the 5-year or 2.5-year period is done. The issue here is, if you're going to transfer or give as a gift or sell property, etc., if you think down the road, this is your only asset. Let's say you have a house, it's your only asset. Maybe it's a good idea to transfer that asset to your children via an irrevocable trust that cannot be changed and which you don't control, or to sell that house and put money again in someone else's name. It can't be in your name. But if you do that, just try to do it, enough in advance, because otherwise you are going to lose out on a period of eligibility. Obviously, this is a more complicated discussion, but I would just say a lot of people think, oh, I can qualify, as I said before, I can qualify for Medicaid and keep control of my assets. You cannot do that. That much I can tell you. If you have assets in your name, you're not going to qualify to a certain degree. You're not going to qualify for Medicaid. And the threshold level is pretty low, and more changes are coming. Why? Because we live in a time of government deficits and increasing applications for Medicaid, and somehow the state, New York State, and the counties have to pay for all of the people who are qualifying for Medicaid. So just be aware there are many issues here. I do want to talk just for a very brief moment about basic documents of estate planning, because if you have these documents in place, estate administration, elder law, guardianship, all those areas will be much easier to deal with. So if you attended my prior program, or you're aware of estate planning, I hope you don't mind if I review this just for a moment. The documents that are effective while you are alive are the healthcare proxy and the durable power of attorney. The healthcare proxy dealing with healthcare decisions, end of life decisions. Do you want to be resuscitated? Who's going to make decisions for you if you're not able to communicate them yourself? The durable power of attorney not being a mental capacity issue, as long as you were capable at the time that you signed the document, but dealing with financial issues, the IRS, New York State, selling a house, bank accounts, insurance, all of that. And then the last will and testament, which is effective only after you're deceased. So I met with new clients yesterday who came into the office saying, we need a will, husband and wife. And I said, that's very interesting, but what about the healthcare proxy and power of attorney? So everyone is fixated. They didn't know about those, and they understood the importance. A lot of people seem to be fixated on the will, right? The last will and testament. But just know that the will, the last will and testament, has no effective power until you die. And you could always make a new one. That's why we call the will the last will. If you make a will today, tomorrow, the next day, they're all valid, presumably, if they're done correctly and signed correctly and in front of witnesses and all of that. But the only one that's effective is the last one, and you can keep making new wills. So just be aware, this is basic estate planning, no frills, nothing fancy. And they do help, all these documents help to make, not only ensure that your wishes are honored, but make things easier for those helping you and those you leave behind. And now let's talk about a trust for a moment. So what is a trust? Does everyone need a trust? No, not everyone needs a trust, but let's talk about what it is and what it isn't. If you think of a trust as an entity, maybe you have an LLC, or you have a limited liability company, or you have some kind of other company, a corporation, maybe an S corporation, or maybe, I don't know what you have, many people here. But if there is nothing in that entity, then it's a waste of time and money. What you need to do with this trust, which we'll define in a moment, is to move assets into the trust. Once there are assets, whether a house, bank accounts, whatever the assets are, insurance, proceeds, as soon as you have assets in the trust, then the trust can actually be formed well, and the trustee, the person who administers the trust, has something to work with. So a trust is not a person, it's not a thing, you can't touch it, but it is a means, a mechanism by which the grantor, that's the person who creates the trust, can control who gets money, when that person gets, or multiple people, how much they get, when they get, why they get, how they get. It's all about the control. And you can get it. You can make the trust inter vivos, which means during your lifetime, or testamentary through a will. If you need a revocable trust, one that can be revoked or changed, then we're talking about an inter vivos or living trust. But I'm going to move on. Again, this is just a basic discussion of administration of affairs. What are some good reasons to create a trust? As I said, it's all about the control. If your beneficiaries currently receive governmental assistance, and if you put in a will, let's say Christy's my daughter, and I put in my will, everything's going to Christy, and Christy receives Medicaid or SSI or all kinds of governmental benefits, and she inherits money from me, she's going to be off the rolls of the governmental assistance, because as you'll see, the sums that you're allowed to keep and receive governmental assistance are very low. So as a result, that's not a good thing for Christy. But if I set up a trust, whether during my lifetime or through my will, and say, Christy can't control the money, however, the money may be used for Christy's additional care or for additional expenses that Medicaid or other other government offices do not provide for her, that's a pretty good thing for Christy. Medicaid planning, we've already discussed, you cannot keep your assets and go on Medicaid. Spendthrift, if any of your beneficiaries, whether it's a spouse, children, grandchildren, etc., don't know how to keep a dime in their pocket, any money they have, they go and spend on anything. So a trust is a way to make sure that your beneficiaries, whoever they are, will have money put aside. The answer will be no when they ask for more money. And there are ways to set it up to protect people who don't know how to be financially responsible. Addiction. Unfortunately, I think we all know people who are, whether it's opioids or illegal drugs, or even alcohol. There are people who are addicted to substances and cannot control themselves, and they spend money freely, or they lose money, or even gambling. I mean, there are many kinds of addictions. If you're concerned that your beneficiary will spend the money right away and it won't be there for his or her benefit in the long run, it's a good idea to create a trust for which the beneficiaries cannot demand any money, obviously, because you want it to last. Ease of administration. So I do work with clients who want to set up a trust, not because they have any of the other issues, but just because they want to make things easy or easier for those they leave behind, meaning all the assets are in the trust. You don't have assets in different houses in different states or bank accounts in different places. Everything's in the trust, just easier. Whom do you choose as trustee? And I would say this about your executor. That's what we call the person who, in a probate proceeding, manages your your estate after you've passed, or an administrator if there's no will, or even for a healthcare proxy or power of attorney as an agent. Choose that person wisely. That person should be someone, number one, who is trustworthy and honest and will keep good books, because we're talking about money here and assets, and this is other people's money. So the fiduciary, whether the executor, the trustee, the agent, etc., that person is holding money, controlling money on behalf of someone else, for someone else's benefit. Choose someone who would be good at that. Choose someone who has time to do that. Maybe someone who's local as opposed to in California. But then again, if you only have someone in California, that's okay. Just know that there may be things that may be harder to handle from farther away. May you be the grantor, the person who creates a trust, the trustee, the person who manages the trust, and the beneficiary, yes, but only in a revocable one that can be revoked trust. But again, that will not qualify you for Medicaid. Okay, so let's talk a little bit about estate administration. Someone has died, and now we have to pick up the pieces. So one thing I will say to you is during COVID in particular, I'm going back to before we go here, I'm going to go back to the healthcare proxy for a moment. I have a number of acquaintances who are funeral home directors. And what they told me, we all saw the pictures with the refrigerators outside hospitals, etc. What they told me was people who had healthcare proxies and agents named in their healthcare proxies to make decisions for them went to the top of the line. Because if no one was able to know, if someone didn't have a healthcare proxy, didn't have an agent already named, there was no one to make a decision for a deceased person as to what would happen with that person. The doctor couldn't, so people were waiting for family members to come forward, et cetera, even without a healthcare proxy. But anyone who had a healthcare proxy, anyone who had with an agent, went to the top of the list to be cared for, meaning that their remains would be disposed of properly. In addition, anyone who did pre-need planning went to the very top of the list. I want to talk about that for a minute. New York State Department of Insurance has a program whereby you can prepay for your own disposition of your remains, whether you want burial, whether you want cremation, whatever you want. You go to a nursing home, funeral home, and you talk to them and you get prices for cremation, for a casket, whatever it is. You do it when you're calm, when you're well. And if you agree, you pay money, not to that particular funeral home, but rather to New York State Department of Insurance. And your money continues to grow. There's interest on it. And after the person dies, there's one phone call to the funeral home and everything is taken care of already. So I'll share with you that I did that for my mother, and it was very helpful. My mother and I had talked about this beforehand. She died about 7 years ago, and it was just very helpful because when my mother passed, I was busy grieving and mourning, and I really didn't want to think about money and which funeral home we were going to and what her funeral was going to look like. So I made one phone call and everything was already done. So I urge you, if you're thinking about it, in particular, if you either don't have family members, I have a number of clients who are either not married or a spouse has predeceased, maybe they don't have children or they're not close with their children, whatever the situation may be, especially if you don't have someone who can make these decisions for you later, do it for yourself in advance. It really is a good thing to do. Okay, enough said. So if someone leaves a will, last will and testament, that's called probate. By the way, there's only one court in New York State which has jurisdiction or the ability to deal with the lives of deceased people, the estates of deceased persons, and that is the Surrogates Court, SURROGATE''S. And which Surrogates Court has jurisdiction, which surrogate's court can hear or can determine issues about someone who has died. We call that person a decedent. It's the county in which the decedent resided prior to his or her death. So if you were on vacation in Hawaii, but you generally lived in Suffolk County, and Suffolk County, meaning it's on your driver's license, your tax returns all have your Bayville address, whatever, you have your governmental documentation with your Suffolk County address, then Suffolk County has the jurisdiction, the ability to hear your case. Intestate means that there's no will. And they're two very different proceedings with different requirements. The intestate, no will proceeding is much more expensive. It takes far longer and more onerous. So if you have the ability, if you haven't made a will, or you haven't looked at an old will for a while, you could do yourself a favor and those you leave behind and make a new will. What happens to the power of attorney and the healthcare proxy after someone dies? Remember I said that those two documents are only valid while you're alive. So once you die, they're no longer valid. If someone is my agent under a power of attorney and I die, and that person goes to my bank to try to get the money, he or she can't and won't be allowed to, because I'm already deceased and the validity of the power of attorney and healthcare proxy is no more. So who has standing to file a petition, whether it's probate or administration? I want to talk about standing, and we're going to look at SCAPA, that's Surrogates Court Procedure Act, Section 1001. We're going to look at that in a moment. Standing means there's an order of priority. Who can ask for the court to appoint someone, whether that person or someone else, to handle a decedent's affairs? We already talked about where the petition is filed, where the person resided. So I'm going to move on to these questions and then we'll go on to SCAPA 1001. Who needs to be notified when any petition is filed, whether it's probate with a will or administration, no will? The family members who would take but for a will. So who is that? We're going to find out in a moment. Let's go to the next slide. So before I'm going to go back up for a second. We're going to go back to who has standing to file the petition and to be nominated. And here is the order of priority of fiduciary appointment. So this is where someone, when there is no will, if there's a will, let's say I have a will and I'm married and I don't want to name my husband as my executor. Maybe he's not good with money, or he can't keep records, or maybe he's mentally incompetent, or whatever the reason is. I can name anyone I want. That's the beauty of a will. Just like the beauty of a healthcare proxy and power of attorney, you choose who the person is or the people are who are going to handle your affairs. Very good to do. Plus, in the will, you say who gets what and how much. But beyond that, you set up who is the person to control the estate. If you don't have a will, you must notify, and that goes back to this question, who needs to be notified? The people who would take, the distributees. That's what heirs at law, next of kin, they're all the same. Distributees, heirs at law, next of kin. The people who would take but for a will. And this New York State determines, this is New York State law. So first on the batting order is surviving spouse. Now, let's say you don't live with your spouse anymore. It doesn't matter. Are you legally married to that person? If so, that person, unless that person is a felon, meaning has committed a felony, a crime, or is mentally incompetent, that person is going to be appointed. That's it. So if you don't want that person appointed, you should know now that you need to make, in your will, you need to make a will, and in your will, you name someone else. children. Now, when I say children, by the way, if there is a surviving spouse and that person isn't a felon and has mental capacity, that person's going to win, hands down. It doesn't matter. Is that person nice? I don't know. It doesn't matter. The court won't care. That person will win and be appointed fiduciary. The end, if there's no will. Let's say there's no surviving spouse, or the surviving spouse is a felon or lacks mental capacity. Then we look at children. Now, we don't mean children as in 18, under 18. We're talking adult children. And among the adult children, it's not like the oldest child has priority. Among the children, it may be that a younger child who steps up to the plate will be appointed, but the children, that's a class. Then after that, grandchildren. So you see what we're doing? We're going between spouse and then to children. We're going down. Then we're going to grandchildren, going further down. And then we go up to father or mother. And I have had fathers or mothers appointed. And then to the side, brothers or sisters. And then it's going to stop. We're going to have a problem. I have a number of what's called kinship hearings now. After you have brother, sister, and you have their children and nieces, nephews, first cousins, etc., the public administrator will step in. That is more expensive, more time consuming. It's really a good idea, especially if you don't have any of these categories right here in front of you. It's a great idea to have a will. Okay, we're going to continue, and here we go. The public administrator will be appointed. Even if you have fairly close relatives, nieces, nephews, first cousins, not going to happen. The public administrator will step in. So anyway, I strongly suggest you make a will if this applies to you. Who inherits from the decedent where there is no will? So what we just talked about, I'm going back for a minute. What we just talked about is who gets to be appointed, who is appointed to handle, to manage an estate. Now we're going to talk about who's going to inherit when there's no will. So when there's a will, the will is going to govern. The only thing I will say to you is there is one person you cannot disinherit. If you are legally married, you cannot disinherit your legally married spouse. We're not talking common law. New York State does not recognize common law marriage. And if you have a valid separation agreement, a legal separation agreement filed in court, you're probably not going to inherit either. But if you are legally married, the legally married surviving spouse will receive not less than 1/3 of the entire estate. Again, this is New York State law. So let's talk about who are the heirs at law. And if we have a general example of mom, dad, and 3 children. If dad dies, mom and the 3 children are going to be the heirs at law. What happens if dad dies and child 1 also dies? I hope you're with me. I'll say that again. Dad dies and child 1 also is predeceased. If child 1 has children, then child 1's children will take the place, the portion of child 1. I hope that's clear. If both parents have passed, then, and there's no will, each child, here there are 3 children, each child is entitled to a 1/3 share where both parents have passed. 1/3. If there were 4 children, it would be 1/4. So if child 1 passes, leaving 2 children, the 2 children of child 1 will each get 1/6. So 1/6 plus 1/6 is 2/6, which is 1/3. And child 2 and child 3, even if they leave children of their own, they still get their 1/3. Let's talk about how much people get, your heirs, your distributees, your next of kin get if there is no will. If a decedent, that's a person who dies, is survived by a spouse and issue is children, or we're going to go into by representation. Issue by representation means you go down, just like in my prior example, where child one died predeceased. And so child one's children take. A spouse gets the first $50,000, 50, and half of the rest. And the other children, by representation, meaning if someone has predeceased, the grandchildren take in their place, the other children split the other half. So the spouse doesn't get it all. The spouse gets 50,000 plus 1/2 of the rest. Now, I will tell you there are certain other provisions which are available to the spouse: a car, a motor vehicle under a certain value, certain household items. But generally speaking, when we're talking about money, or if there's a house to be sold, whatever the case may be, this is the format. If there are no children, that's what issue means. The spouse gets everything. By the way, this is a good time for me to say, when we say child, we mean not only biological, but also adopted, legally adopted child, but it's not a stepchild. So let's say you're in a second marriage and you're very close to your stepson, stepdaughter. That person, and you die without a will, that stepson, stepdaughter will not inherit from you. We're talking here about either a blood relative or someone adopted. Just keep that in mind. That's a really good reason why someone should make a will or set up a trust, when you want to make sure that a non-blood relative or a friend or whomever or a charity will receive the money. If there are children or grandchildren and no spouse, then the children get it all, like we said before. And then on and on. So you see how it works. You may have heard the term per stirpes, the Latin term. It just means that the children of the person in the prior class take that person's share. Okay, I hope that this is clear. This is all New York State law, by the way. Here are some special considerations where family members receive government benefits. Now, this is also about qualification for Medicaid. So look at what you're allowed to have or receive on a monthly basis to qualify for Medicaid. Assets up to currently $16,800. That's it, total assets. That means bank accounts, house, everything, not more than $16,800. And monthly income of $934. Now, you may be aware of something called a pooled trust, P-O-O-L-E-D, a pooled trust, which Medicaid allows you to pool, to put your money together with other people in order to qualify for Medicaid. That is subject beyond this program. It is an option, but that is also a complicated option, and that also has cost to it, and not everyone qualifies for that. But in any case, please be careful not to name anybody who receives governmental assistance who would be harmed by, it's ironic to think, would be harmed by receiving an inheritance. Do not name them as joint owners or beneficiaries of your assets. It would be an immediate disqualification for them, and it would not be a good idea. Okay, let's talk about guardianship of an incapacitated adult. Again, we're talking capacity, mental capacity. An adult is someone who is over 18 years, so age 18 or over, and that person may need help to care for his or her needs or manage property. This kind of case is brought in Supreme Court. It's sometimes scary to when you start to lose the ability to handle your own affairs, and there are times when definitely a guardian is necessary. But I've personally seen times when adult children are fighting over who gets to control mom's or dad's money. And that's not a very pretty sight. So just be aware that if this happens, this is a very expensive proceeding. It's about $20,000 with all the experts and trial. And it's not a great thing to do, but this is part of elder law, so I'm including it here. Guardianship or conservatorship, and as it's called in some states, we happen to call it here guardianship. Just like in New York, we call the person who marshals your affairs after when you have a will, the executor. And so, for example, in Florida, that person is called personal representative. Same thing, just different name. But guardianship is an arrangement where the court makes a decision as to who is going to control where the incapacitated person, again, mentally incapacitated, lives, what happens to his or her money and assets. And that person can no longer, that incapacitated person, adjudicated, meaning determined by the court, can no longer make decisions on behalf of himself or herself. What about guardianship of a child? So normally, if you have any children and they are under the age of 18, and they're your biological or adopted children, you're their guardian. You make decisions for them, as long as they are not married or in military service. If they are, then guardianship does not apply to them. Okay, I think we did that. A developmentally disabled person also may have about that person, a guardianship proceeding may be brought. That is a different type of proceeding. That is usually not for someone of a mature age who develops incapacity, whether it's Alzheimer's, dementia, whatever the state may be. This may be someone perhaps who is mentally retarded or has disabilities, from a young age, maybe from birth. Someone who probably has not lived outside of either a home or some kind of secure facility. And there are proceedings for that person as well. I want to talk about a few miscellaneous matters that deal with estate issues, some of which we've touched on before. If you have a bank safe deposit box and that's where you're keeping any documents, that's really not a good idea, because I've seen it many times. Even if you hold an account with someone else, a joint owner or etc., the bank will not let that other person come in once you have passed or you're incapable, so incapacitated, excuse me. So it's much better to have a fire safe box in your home. If you're interested in a link for one, I give them to my clients, these links from Amazon, Walmart, etc. It's about $50, 50. It's delivered to your home. It's not for theft. It's to make sure that your documents are preserved. And that way someone can access your power of attorney or your will if necessary. We've talked about the importance of all kinds of insurance. I would suggest that I want to talk about life insurance for a moment. If you have family members who are dependent upon you, then term life insurance is a very good product. If you think if something happens to you and you're no longer able to provide for financially for someone, and if something happens to you, at least that person would have money to live on, or pay off a mortgage, or go to school, or whatever the case may be. But other than that, when your children grow, take that money, this is just my suggestion, put it into long-term care insurance, start saving or putting money aside for yourself, for your care, to make sure that there is someone to take care of you. I told you that I've had long-term care insurance more than 20 years, and I insisted that my husband also get long-term care insurance. By the way, this isn't a spousal thing or whatever. Every person has to have his or her own insurance, right? Just because you're married or part of a couple, That doesn't mean everybody gets, but I insisted my husband get because of the clients I was seeing. And in the meanwhile, I've seen many couples where either one member or both members of the couple did not have, neither had a long-term care policy. I can think of one in particular. The husband had a stroke and they didn't have long-term care insurance, and the wife gave up her career. She was an accountant. She gave up her career and she stays at home with him because he cannot function himself by himself, and they don't have long-term care insurance. So they've already sold a lot of assets to pay for his care and surgeries, etc. So it's really a blessing to those in your family and those who would help you to have long-term care insurance to take care of your own needs. Okay. Check beneficiary designations. If you've gotten nothing else from this program, I hope you're going to focus now, because this is free legal advice. It's something only you can do, and it's incredibly important. If I have a bank account and I name as my beneficiary payable on death, POD, or transfer on death, TOD, to Christy, when I die, all Christy has to do is go to the bank with my death certificate and her ID, and she gets the money right there and then. Can't be easier than that. You don't have to wait for probate. You don't have to go to a court. You don't have to do anything. You get the money right away. What happens if Christy dies before me and I don't update? I don't have a contingent, so she's the primary beneficiary. I don't have a contingent beneficiary and I don't update my records in the bank. Then the money will go through the court, and the court will be nosy and look into things, and they'll have to wait until they figure out who gets what. So really, it behooves everyone to check your beneficiary designations. I've had clients tell me, oh, I know who my beneficiaries are. I took care of it, whether for insurance policies or bank or brokerage accounts, whatever it may be. Please go and do it, because they come back and say, oh, I didn't realize I didn't have a contingent, or the person I named I don't talk to anymore, or whatever the story is. So please go and look at your beneficiary designations. Again, it doesn't cost you anything. You must go to each institution and make sure that it applies to all accounts within that institution. I will say there is only one type of asset, actually two types of assets, which cannot have a beneficiary designation. And that's real property. That's anything attached to the land or a building on the land. So a house, a commercial building, even a condo is considered commercial property. Or if you own a co-op and you don't own land, but you own shares in a corporation, that also you can't name a beneficiary. So that will, unless it's in a trust, you will have to probate if you have a will, or do an administration, if not, to figure out who gets that. Pre or post nuptial agreements. Now I have here for second marriages and beyond, but I just did a prenup for someone in a first marriage and going into a first marriage. They're getting married in October. And my client was the groom, and he has significant assets and his bride does not. She also has debt. So, you know, a lot of couples fight over money, but when you have everything arranged in a prenup, prenuptial agreement, there's really nothing to fight about. A postnuptial agreement is different. It's for after the marriage, and it's a little more complicated. But if you have assets, whether it's a blended family and you don't want his children to get or her children to get, you want your children to get, however you want it, that is the way to ensure who gets what, and etc. Gifting. So you can give to any person you want up to $16,000. You don't have any tax consequence. It's a nice way to see your family members enjoy money if you have it. I don't know if you do, but to see your family members enjoy money during your lifetime. I see a lot of grandparents doing that. And so whether for college college tuition or other things, it's just a nice thing to do if you have the financial ability to do it with no tax consequence to you. I do want to talk a little bit about deed transfers because they are relevant to, I don't know why that did that, I apologize. They are relevant for a lot of people. They think, oh, I'm going to transfer during my lifetime, I'll transfer the house or whatever it is to the children. But there's a problem because, and I don't want to get too technical here, whatever the amount is that you paid for your house, that's called your cost basis. And every person is entitled to an appreciation in value, an increase profit, basically, in the sum of $250,000, if that's your primary place of residence, $250,000 that you don't pay any capital gains tax on. You see, taxes are very important in this issue, in this whole area of law. And if you're married and both spouses are on the deed, then you're talking 500,000. But other than that, even if you're not married or just one person on a deed, it's $250,000. When you transfer or give as a gift property to your children or your whoever you want to receive, and you're not receiving money in return, meaning you're not selling to someone on the open market for fair market value. I hope I'm not going too much into the weeds here. If you're not selling whatever an outsider would pay for your property, then your recipient is going to get your same cost basis. For some of you in the audience, maybe you purchased your home for $50,000 and now it's worth $500,000. So when you give that house for no money to your children, they start at a $50,000 cost basis, yours. As opposed to, if you own the house, I'm picking a house because it's easy to relate to. If you own the house and then you die, your beneficiaries will receive a step up in basis, meaning the fair market value of your house at the time of your death. So why is that important? Because if the value at the time of your death is $500,000, and if the beneficiary sells the house for $500,000, there's no capital gains tax. Sounds pretty good, right? But if you transferred the house to your daughter during your lifetime, and so the cost basis for your daughter is $50,000, your same cost basis, there's no step up. The kicker is you have to die to get that step up. 50,000, and she goes to sell it for 500,000. Even if she lived there, 50 plus 250 is 300. She has a $200,000 gain that she has to pay capital gains tax on. That might be, I don't know, 40%, 30%. It's a lot of money. So sometimes a deed transfer is appropriate. Sometimes it's not. I would say before you decide, you're definitely, and one other thing I want to say, I had a client come to me who in Nassau County, who did a deed transfer, I don't know why, to herself and her son. She owned it beforehand. She is in her 70s. And in Nassau County, you get an additional exemption on your real estate tax if you are over 65 years of age. All the owners are over 65 years of age, and you're under a certain income bracket. When she brought on her son, who is under 65 and makes more money, she lost that $5,000 a year tax exemption. That was not a good decision. I don't know who told her to do that, but she came to me and we transferred it back to her. And so at least she got the exemption this year. But my point is, whether to do deed transfers, that's a very complicated issue. And I do handle real estate as well as elder law and estate planning and administration. Go to an attorney who understands these issues before you start making decisions. And I see we're running late. I apologize for that. I just want to end I usually do two quotations by Benjamin Franklin. In this world, nothing could be certain. It said, nothing can be said to be certain except death and taxes. I met with a client, actually a husband and wife last week. The husband, who's in his 80s, never done any estate planning. The wife dragged him there. He didn't want to be there. He said to me, I don't want to die. I said, you're going to die. Everybody's going to die. So is it going to be on your terms or the government's terms? That's your decision to make. but that's what it is. And by failing to prepare, you are preparing to fail. So I encourage all of you to do your planning to make sure everything is in place so that the administration of your estate will be that much smoother. I hope everyone is well. And with that, I am done. I'm going to stop my share. And Christy, thank you so much for the opportunity to present.
No problem. We have a question in the chat. Janet wants to know if accounts have POD, do they go into probate?
Very good question, Janet. No, they do not.
And what is
go out-
POD?
POD is payable on death. So what I
Got it.
said, Christy, was if I name you beneficiary on my bank account at Chase Bank, and whether it's every bank has a different name, whether it's POD, payable on death, or TOD, transfer on death, all you have to do when I die is bring my death certificate and your ID, and you get the money on the spot.
Okay, I'm going to stop the recording now.
Okay.